Good evening, everyone. Okay. Good evening, everyone. Welcome to Grant Thornton's webinar on one of the most awaited decisions by the Supreme Court on the most favored nation clause. You may be aware that the MFN clause in an Indian tax treaty with a country enables a taxpayer of such country to import the provisions of India's tax treaty with another country, of course, subject to the country being a member of the OECD, if the scope is restricted or if the rate is beneficial. The judgment that has been delivered by the Supreme Court, by the Honorable Supreme Court, in the case of Nestle, of course, it's a bunch of three appeals, Nestle, Steria, and Concentrics, clearly radically alters the manner of interpretation of this important aspect of India's tax treaties. Clearly, this judgment does have ramifications. To what extent, I think, is for each one to assess and for each one to judge. However, this evening, we, in fact, at GT, decided that we should get the best of experts on this particular panel to discuss this important aspect which impacts international tax, impacts international business, and the way policy making, including dispute resolution and judiciary, will view this important event. And to add to our esteemed panel, we have Mr. Pramod Kumar, who's been a member and a vice president, Income Tax Appellate Tribunal, during which he has authored over 15,000 judgments on various nuances of direct taxes. He has around 23 years of experience and is a director of the International Association of Tax Judges. He is an external advisor with GT Bharat. We are honored to have him with us to discuss the nuances of the Supreme Court verdict. Welcome, sir.
Thank you so much.
Next on the panel, we have Mr. Ajay Vora, who has been practicing since the last 40 years. Mr. Ajay Vora, senior advocate, has been practicing since the last 40 years in the area of domestic and international tax and is a leading arguing counsel before tax tribunals, high courts, and the Supreme Court of India. Thank you, Mr. Vora, for joining.
Thank you.
We also have with us Richa Sani, chartered accountant, who is an international tax expert and has over 25 years of experience in tax and regulatory matters. Welcome, Richa.
Thanks, Raj.
And I am Rajshri, the senior advisor with Grant Thornton Bharat LLP. I will be moderating the session. I mean, you can imagine a panel with this, with the kind of experts we have on this panel. My job is going to be very easy. I know that, because people and the members on this panel clearly need no better introduction than we've got the best of brains today. Okay, so let's make the most of it. Let's hear them out. I will now be requesting Richa to actually run us through a small PPT, which in fact will give us a flavor of what this decision is all about, what are the issues emanating, and then from there on, we will take it forward. Over to you, Richa.
Thanks, Rajshri. Now, let me begin with a brief overview of what an MFN clause is all about. Now, a typical MFN clause in an Indian tax treaty with any country enables a taxpayer of such country to import the beneficial provisions of India's tax treaty with another country, and we'll call it a third country, which is an OECD member and which is subsequently entered into if the scope of such treaty is restricted and the rate is beneficial. Now, I'll request you to take note of the term, which is a OECD member. In India, we have a dozen plus tax treaties which contain the MFN clause, and just on a plain reading of the language of these MFN clauses, one could bifurcate them into two categories. And I'm just saying this is the language. One is the seemingly self-operating or the automatic MFN clauses. And these are in the case of Belgium, Netherlands, and France. And the other set where the language itself suggests that a negotiation is required to import any benefit or to seek parity with the benefits given to a third country. So this is how the language will kind of demarcate these clauses. Now, in the backdrop of this controversy are two sets of Delhi High Court decision, and I'll take up the Steria case first. Now, Steria is an Indian company that entered into an agreement with Steria France for management services. And based on the protocol in the India-France treaty, which contains an MFN clause, Steria contended that the restrictive definition of FTS as per the India-UK treaty must be read into the India-France treaty. Now, this plea was not accepted by the AR, which held that protocol is not an integral part of the treaty. And even if conditions of MFN clause are satisfied, a separate notification is required to incorporate the restrictive definition of FTS as per the India-UK treaty into the India-France treaty. On appeal before the High Court reversed the AR ruling and held that indeed protocol is an integral part of the treaty and there is no need for a separate notification. The second set of cases, and I'll talk about concentric facts here, is that in this case, the Indian company is trying to remit dividend to its foreign parent, which is based in Netherlands. The taxpayer filed an application for obtaining lower withholding certificate of 5%. And when we say 5%, what they were trying to do is trying to import the beneficial rate from Indian treaties with Slovenia, Lithuania, and Colombia by virtue of the MFN clause in the India-Netherlands treaty. Now, it's important for us to take note of the fact that Slovenia, Lithuania, and Colombia, all three of them were not OECD members when India entered into tax treaties with them, but they became OECD members later. This benefit was not granted by the tax authorities and they issued certificate at the rate of 10%. Now, the High Court in this case again opined in favor of the taxpayer by saying that the protocol is, yes, indeed a part of the tax treaty. And there is no requirement of issuing a separate notification in order to apply the provisions of the protocol or to operationalize that. And as far as interpreting the term is a member of OECD is concerned, it says that all you need to see is the status of these countries on the date of application of these treaties. And in this case, it was the date of seeking a lower withholding certificates. The High Court also relied on the executive decree of Netherlands and opined in favor of the taxpayer. Now, the matter traveled to the Supreme Court, and where the Supreme Court was deliberating on a batch of appeals and two issues which were in front of the apex court. The first one being whether a separate notification is required to operationalize the MFN clause, and this is dehors the language of the MFN clause. Further, can parity be sought by a country for benefit given by India to a third country which is not OECD member at the time when the treaty is entered into, but becomes a member at a later point of time. Now, while discussing and deliberating upon this decision, there were certain key observations of the Supreme Court which I would like to point out. The first one being that treaty-making power rests exclusively with the Union, and this is coming from Article 253 and the Union list. But in India, unlike some other countries, a treaty does not have a force of law merely by virtue of signing it. And they highlighted that Article 253 of the Constitution of India recognizes this position. Therefore, merely upon entering into a treaty or a protocol, it does not result in automatic enforceability in courts and tribunals. For the provisions of these treaties and protocols to confer rights upon parties and to make them enforceable, there has to be a specific notification under Section 90 of the Income Tax Act. They then went on to discuss in detail the treaty practice in India, and they held that treaty practice in India points to a consistent pattern of behavior and which cannot be ignored. That when signatory to an existing treaty can avail benefit of India's treaty with a third country only after a consequential amendment. Then they highlighted that this amendment would definitely be preceded by exchange of communication and negotiation. Then it examined the executive degrees issued by Netherlands, Switzerland, and French authorities to grant benefit of 5% under the dividend clause. And they opined that these do not bind the Indian authorities. On the issue of how to read is a member of the OECD, the Supreme Court pointed out that Lithuania, Colombia, and Slovenia were not members of OECD when they entered into treaties with India, and they became members much later. This is a really significant fact, and the expression has a present signification and derives meaning from context. So accordingly, they held that when a third country enters into a treaty with India, it should be a member of the OECD at that point of time for an earlier treaty country to claim parity. So in nutshell, the key takeaways from this decision are that one, a notification is required. It is a must in order to operationalize MFN clause in a tax treaty, and this deholds the language of the tax treaty. There is no automatic integration of benefits based on the stipulation provided within the latter treaty. A separate notification is required. And thirdly, as far as the member status is concerned, the third country must be a member of OECD on the date it enters into a treaty with India. And that is the critical point of time which one should examine. That's about the key takeaways from the decision. I'll hand it back to Rajshri now.
Thank you very much, Richa. That was quite well put across. I will now, kind of have my first question directed to Pramod Kumar sir. So how do you see this verdict in the light of the principles laid down by the Vienna Convention and the principles enshrined in the Constitution of India? So A, your reaction to this judgment, and then if you could help answer the question.
Thank you, Rajshri. As Richa has rightly pointed out, there were two questions. And when we think of these two questions and what their lordships have decided, in para 44 to begin with, they've talked about the constitutional part and how, in the light of the Constitution of India and the constitutional provisions, a treaty is integrated into the domestic system by way of lawmaking by the parliament. But then this paragraph needs to be read along with para 72, where they have recognized two situations. One situation where enactment of law is subsequent to the treaty making, and second situation when the integration process takes place by virtue of an existing enactment, and what the word they have used is legislative device for notification. Now, if you take the second step into consideration, the next thing would be, do we need a separate notification for giving effect to the protocol? That's where I think there could be two ways of looking at this. One way is when the treaty itself is notified and the protocol is notified as a part of the treaty, you cannot have yet another notification for giving effect to the corollaries there too. But the language that their lordships have used, and particularly when you go towards the conclusion part, when they talk about the past practices, there is no differentiation between different kind of protocol clauses. As Richa was pointing out, there are some protocol clauses which are self-operational and some which deal with further negotiations. So this is where there is a ray of hope, because if the issuance of notification is seen as a policy making, as an act of policy making, probably this is an area where courts cannot interfere, where there cannot be an adjudication whether it has been rightly or done or not. But when it is seen as an administrative action to implement a policy decision taken earlier, which is what protocol reflects in some cases. As was being pointed out, there are some situations where protocol neatly defines what triggers what. In the second situation, when they say this is the trigger, but the effect is a negotiation. So if the first kind of MFN clauses are to be treated as the administrative acts to implement it, I would think this litigation is not the end of the road, because there could be calls to be taken on whether the implementation part is done rightly or not. Now, talking about the constitutional framework, see, there's so much of emphasis on Article 253. Now, Article 253, being a part of Part 13 of the Constitution, is a part of the bunch of 10 articles which talk about the division of the legislative powers. Undoubtedly, there are areas in which only the union can legislate. There are areas in which only states can legislate. And there are areas where both can legislate. And all that the Article 353 does is that, notwithstanding anything contained in that division of power, when it comes to implementing an international agreement or treaty, the parliament has the exclusive power. That's more like an enabling clause about who has to exercise that power. But the integration process which every treaty has is not on the question of on the subsequent enactment. That's part one. Second part, which is the most significant part of this decision, is when their lordships have referred to the past practices. And in the past practices, they have particularly referred to the negotiations which have taken place between the contracting states. Now, what needs to be borne in mind is, and I do not know whether this part was there in the before the proceedings, the Indo-French Treaty, for example, which is what was picked up in Steria's case, was entered into 92. It was notified in 94. And I'm sure the taxpayers were following their legal course of action. As a matter of fact, when I heard that appeal, and that was the first MFN order way back in 2001, the appeal was filed in 1998. So you can imagine, within 4 years of treaty being implemented, this is something which was before the domestic courts. And that appeal was also a departmental appeal. So Commissioner Appeal has given relief on that point. And the issuance of notification took place much after that. Now, it appears that the courts have proceeded on the basis that it is the act of issuance of notification in which countries voluntarily participated. But if I am advising a French company, what would I do when I think that Indian government is not giving it proper effect? One, I would ask them to follow the legislative course, the statutory course. And second, perhaps I would also ask them to persuade their government to take it at the government-to-government level. One possible way of looking at this was that this parallel exercise of negotiation between the government was without prejudice to the statutory rights of the SSE, and probably what aspect seems to have been overlooked, that within 4 years of treaty being implemented, the matters were before the domestic court. So given the time limit that you have given me, I would stop here and take my much more learned colleague take over.
Thank you. Thank you, sir. Mr. Vora, your initial reactions on this particular judgment, and how far can the tax department, I mean, first is I would like to, get a sense of what is your initial reaction on this judgment?
I think so far as you very rightly, projected, there are two issues that were before the Supreme Court. So far as the applicability of Slovenia, Lithuania, and Colombia treaties with respect to a reduced withholding of 5% on dividends is concerned, I thought that was an open question. It could have gone either way, and the Supreme Court has taken one view that the benefit of the treaty that is sought to be taken ought to have been a country which was part of the OECD at the time when the treaty was signed. So notwithstanding that it has subsequently become a member of the OECD, that treaty benefit cannot be availed by a third country. So I think that I have no quarrel with the decision that has been taken, and as I said, it was an open question. Now, insofar as the second issue is concerned about the notification, to me this has come as an unexpected ruling from the Supreme Court, that a notification is necessary in order to effectuate a protocol, dehoards the language of the protocol. And as Richa pointed out, and has also been alluded to by Mr. Pramod Kumar, you may have the protocol with different languages. the Indo-French protocol is automatic, it is self-effectuating. The India-Swiss treaty protocol requires a negotiation between the treaty partners. Now, having said that, the Supreme Court says that the notification is necessary. Now, the question will be, and as Mr. Pramod Kumar very rightly articulated, whether this is going to be a ministerial act of implementing the policy decision or the agreement between the two sovereign nations, or is it something that the Indian government can, sit in judgment and decide whether or not to implement what was agreed as part of the protocol, and which in fact has happened in some of the cases which the Supreme Court has taken note of to say that this has been a consistent practice. I would be thinking that one of the contracting entities is reneging on what has been agreed and what is the understanding between the two contracting nations. Now, if that be a situation where the protocol provides that if the rate of a particular income, the rate of tax on a particular income or the scope of that particular income is subsequently altered or modified or reduced to the advantage of the taxpayer, then that has to be read into this first treaty of which the non-resident is a resident. Now, in that situation, I don't think it is open to India to say that we will not implement this part of the agreement that has been reached and documented in the protocol and decide to say that, look, notwithstanding what we agreed, according to us, the scope should be, X minus Y and not X that was agreed between the parties. This question, I think the Supreme Court was not seized of, and the Supreme Court is probably not cognizant that these are the ramifications that will arise when the Supreme Court says that a notification is a mandatory condition, it is a necessity before effect can be given to the protocol. So I think, to my mind, this is a bolt from the blue, not something that one had reckoned with, having regard to the plain, simple language of the protocol. And as the Supreme Court said in Azadi Bachao, that this is not, the treaty is not a document framed by the lawmakers on either side. You have to respect the understanding between the parties. It cannot be interpreted like a statute. And if the parties agreed that a limited scope of a particular income will be read into this treaty, notwithstanding it was signed earlier, must be respected, must be implemented, and must be given effect to. So I think that's my initial reaction on this judgment. And of course, it will open the Pandora's box, as I would understand it.
Sure. Thank you, sir. So what happens in case of, the ongoing assessment appellate proceedings, which is what you're touching upon right now, in fact, saying that it opens the Pandora's box. Whether, as a taxpayer, are they expected to withdraw their claim on account of this MFN if they have made such a claim during their, assessments or appeals? Where does that leave the taxpayer today? That's one question. The second is, how far can department go back for reassessment? Is it 3 years or are we talking of 10 years?
I think you need to dissect this question into two parts. One is from the deductor's perspective, where you have Indian remitters making payment. And I think before I answer the question, let me say that insofar as the reduced withholding on dividend is concerned, I think that's not the larger question that will plague the industry and plague taxpayers. The question will be the unintended effect of this judgment on other streams of income, such as fees for technical services, where many developed countries have this clause, the MFN clause, where you seek to reduce the scope as also the rate of tax with regard to the taxes payable on FTS. Now, in that situation, from a deductor standpoint, one would be the situation for the past. Can the deductor be held as an assessee in default for not deducting tax at source, assuming that the notification that has ultimately been issued is not in line with the protocol? So in that situation, the department may proceed against the deductor under section 201 for short deduction of tax. And then the question will be that whether the tax can be recovered from the deductor in view of the fact that the deductee or the payee may not have undergone an assessment in India. So those will be legal challenges, and there are enough ammunition to guard and defend against such an action that may be taken. But to answer your point, it is likely that the government may focus under section 201 to tax deductors for the shortfall in the tax that has been withheld. And similarly, the reopening for the deductee or the payee, I would think that this is not a case of income that has not been disclosed, or it is not a case where tax has not been correctly withheld. This can't be regarded as undisclosed income merely because it suffered tax at a lower rate, as opposed to what rate should have been applied if the Supreme Court judgment is to be implemented. Now, in that view of the matter, according to me, merely because the foreign company has received a higher remittance with a lower withholding, and therefore it has excess monies or excess cash being remitted, that does not become an asset, or that does not become an undisclosed asset, which will give the handle to the department to reopen the case for 10 years. I would think the limitation should be 3 years.
Thanks. Yeah, I pretty much agree to that argument. The fact that this stems from the protocol and of course the notification which is to be issued, because that is what the gist, that's what's coming out from this decision as well. I would now Mr. Pramod Kumar, I would ask you just a question saying whether the MFN notification can be called into question on merits in the courts, and whether a mandamus could lie against the non-issuance of notification to implement the MFN?
I think on a personal note, I would think yes. But that would, of course, be a difficult proposition for the arguing counsel like Ajay to convince the courts to take that call on merits. But please understand, the first and most fundamental issue that needs to be addressed now is whether the issuance of notification is a policy-making decision or is it a ministerial act. If it's a policy-making decision, I think we are out of the court. If it's a ministerial act, then two consequences arise. One, it's a clear violation of Article 26, because then you are not implementing the treaty in good faith. And two, if somebody has a power to do something and it doesn't involve policy making and he refrains from doing it, then courts can surely intervene. So I would think that we are in for the second round of litigation, court battles, where the question which must be adjudicated is why should these MFN clause, particularly which are self-operational clauses, to borrow Justice Muralidhar's terminology, or what you call popularly automatic clauses, in respect of those MFN clauses, whether issuance of notification is a ministerial act or not, I would think it's an entirely ministerial act. And consider this, that not only the notification, but protocol is notified as a part of the notification. Take, for example, the case of Indo-French notification. When you read the notification clause, and I have it here, the notification very clearly says in para 2, in an exercise of the powers, etc., the central government hereby directs that the provisions of the said convention shall be given effect. And then you read the protocol, which is notified along with the treaty. Protocol says, at the time of proceeding the signature, etc., the undersigned agreed to the following protocol provisions which form an integral part of the convention. If that be so, issuance of notification is a ministerial act. But I'm sure there will be something to be said by the other side, and the department has all along taken a stand. So it might take a little time and before this matter gets resolved. I'm particularly hopeful.
Thank you, sir.
I think, Rachit, if I may add, I think
Yes, please. Yes.
Pramod has very rightly said, and I would think that there will be a case of mandamus if there is delay in issue of notification, or if the notification provides that the protocol will take effect from a date later than what was agreed between the parties, or if the protocol provides for a certain, but the notification takes back or does not permit that kind of relief. I think those will be issues that can be gone into in a writ before the court to say that the protocol ought to have been implemented, having been reached as an understanding between two sovereign nations. Now, that's one aspect. The second aspect, I think, from your side, I'll raise the question to Mr. Pramod Kumar. Of course, he is not adjudicating anymore. But if it had come before him, that if the relief in terms of the notification is different than what was agreed in the protocol. For example, let us say the scope of a particular article is sought to be reduced by virtue of a favorable treatment in a subsequent treaty. Now, in that situation, can the tribunal say that this is what the protocol provided, notwithstanding that the government has come out with a notification which is at variance with the protocol? We would need to implement the protocol as part of the treaty. Because as the court said, the protocol is an integral part of the treaty, and to that extent, I don't think there is any diversion or divergence in the Supreme Court judgment.
Frankly, when this issue came up before me, and that was the first MFN decision way back in 2001, I did not take a half an hour to take my call. There was not slightest of doubt in my mind. Today, when you have a Supreme Court judgment which has made some observations which can be construed possibly against, I'm sure all tribunals will be extremely cautious. So what happens today is a different story, but until the time we did not have the benefit of this Honorable Supreme Court judgment, there was there was not slightest of doubt about it. And as a matter of fact, and if I remember correctly, in my decision, which I wrote way back on 28th December 2001, I said because by that time, the interesting thing had happened was when the litigation started, there was no notification. During the course of the litigation, and as the SSC was also taking up probably with the government level, this notification was issued on 10th July 2000, if I'm right. So the finding of the tribunal was that this notification is issued as a measure of abundant caution, but that is not something by which tribunal will be guided.
Sure, thanks for that. And one thing that actually was going through my mind while we were discussing this and pointers were being shared, what happens to this entire, from a business standpoint and from an economic standpoint? Today we are, as a country, we are on the global map. Okay, clearly, there's no doubt about that. Question is, we also have businesses having presence in these respective jurisdictions, right? And of course, not getting into the economic relations and political relations. I think that is not something which is a subject matter of discussion at all today. But I would now turn to Richa. And Richa, what do you think? How are businesses going to view this? One is yes, on the dispute side, I think Sir just shared his thoughts, and pretty much that it's a consistent view in terms of that's what our thinking is. However, from a business standpoint today, when I'm negotiating contracts, so I could have business contracts which have already been negotiated, could be possibly be net of tax contracts, or second, where contracts going forward, I will probably, if the other, if we are the deductor, we will not take the risk, and we will say that, okay, we will deduct tax without denying the benefit of the MFN clause. What happens with the tax credits? Will the other party actually get the credit back in the home country? So, i.e., in essence and in substance, adding to the overall cost of business.
Yeah, actually, as you rightly pointed out, contractually, you would see that in many cases, in Indian scenario, taxes are borne by the Indian party. Now, any additional demands that arise at this point of time will definitely add to the cost and to the cost of Indian parties. Now, to what extent that happens will depend upon the extent to which this is retrospectively applied by the tax authorities. Now, as far as the current contracts are concerned, yes, there is a need to evaluate the existing contracts to assess if at all there is a renegotiation, which is possible. And even if in a case they are not bearing the cost of the taxes in this case, they have an exposure of being considered representative assessee. So that is, again, from an operational point of view, a big challenge. Now, coming on to the foreign party. Now here, as we saw that whereas in some of the recent decisions, the SC has specifically said that these are going to be prospectively applied. In this particular case, it has not barred the retrospective application. So it's going to impact the past transactions. And as I said, it remains to be seen to what extent the department opens up past cases. Now, there will be twofold issues for the non-residents in such cases. One is that will the non-resident be able to file for a claim in their country, the respective countries, for any past transaction where there is an incremental demand now, considering that there might be time barring situations happening there. The second situation could be that even in the future cases, whether the other country takes this additional tax as to be arising not on account or not in accordance with the tax treaty, and they may be denying credit on that account. So both these fronts, there could be a challenge which will be faced by non-resident taxpayers. And there is a possibility, and on these situations, that there could be a situation of double taxation which could happen.
Sure, which in turn means that, it is again wherein we move away from business and we need to look at the tax cost once again. So maybe the tax department within corporates also are going to be busy, apart from, of course, what position they take in the tax returns and the other assessment proceedings that's going on. I would now, Sir Pramod Kumar, sir, this question is now to you. How see the road ahead, and what could be the possible solution to mitigate the hardship of the taxpayers in the present situation?
I think I'm too much of an optimist, but even then, I still have this from the government. I'm sure one of the most important thing and the biggest hallmark of this government is that they are proactive, they are their ears firmly on the ground, and they're ready to take tough calls. I have a hope that CBDT will come up with some kind of measures which might mitigate the undue hardship to the taxpayers. That's a hope, of course. The other thing is litigation aspect. I'm firmly of the view that in many cases of self-operational MFN clauses, these are likely to be held to be ministerial acts for implementation of the MFN clauses, and therefore notifications and also non-issuance of notifications will be subject of challenge in writ petitions before the honorable courts. I have faith and hope, and this is my understanding, that SSC has an excellent chance of succeeding in proper implementation, at least of this self-operational clauses before the honorable courts. The only thing which needs to be pointed out, which needs to be demonstrated, is that these are not policy-making calls. The factor which goes against the taxpayer is the negotiations which have taken place between the contracting states. But then I'm not privy to this. But to my mind, these were parallel proceedings at the governmental level, and SSC at no stage gave up the recourse to the legal provisions. So that's the other aspect. Third is in MAP. I don't know how successful it will be. Probably it could be taken up. Even the government, to be honest, I don't think government is as serious about it, except, and everything started when there was some blatant misuse of this provision of the self-operational clauses with respect to the dividend thing, where very aggressive tax positions was taken. Now that issue is settled in favor of the government, and rightly so. Then government may also come up with some kind of measures again, either for the proper issuance of notifications, or they should also, read the writing on the wall about the possible litigation effect. So that should make them see some reason. As far as the reopenings, etc., are concerned, that is going to create quite a bit of, they're going to keep you busy, but I don't think any practitioner wants to be busy in this kind of a work. This is going to be real difficult situation. As far as penalty proceedings are concerned, they are unlikely to be even initiated, but even if they are initiated, they will not be imposed. And even if these are imposed, they'll be very happily deleted by the honorable courts. So nothing will really turn on those kind of penalty proceedings except excessive burden to the department. So I would think that we should wait for at least next 4 or 5 weeks as to how things unfold.
Sure. Thanks for that, sir. Mr. Vora, do you think that, do you expect a reference to be made to a larger bench of the Supreme Court in this case?
I think easier said than done. It's not easy, to have another bench review the judgment and then decide to make a reference to a larger bench, and especially when there is a pending matter. You can make a reference to a larger bench in a pending matter. I don't think at the moment we have any matters pending in the Supreme Court dealing with this aspect. If there is a subsequent decision that comes where, subsequent judgment which is appealed against and is pending in the Supreme Court, maybe if the benefit of the MFN clause is sought to be denied or is sought to be delayed on account of the non-issue of notification or a delayed issue of notification, I think that question can be raised. And the various facets which have not been dealt in this judgment can be brought to the notice of the court to say that this requires reconsideration if this decision is to be applied with respect to other such controversies. So at that stage, you can make out a case for reference to a larger bench. Now, having said that, I think importantly, steria judgment, of course, has been set aside, and that was one of the cases in this batch. But if you look at the decision, one decision in APCO's case from the Delhi High Court again, that has been detagged from this bench. From this judgment, that has not been dealt with on the basis that it relates to the interpretation of the India-Spain DTAA. Now, there also the issue would have been identical, whether the benefit of the MFN clause could be read into the India-Spain treaty, dehorse the issue of a notification. So I really don't know whether the court intended this to have anything applicable with respect to other than the dividend clause. And the question whether the notification is necessary should be seen in that context. Obviously, that's not how you read the judgment. But it seems to me that, the entire focus was on this question of the applicability of the reduced 5% withholding tax. It's a tall shot. I don't think it will succeed. But this is how the court, when it detags this in India-Spain DTA decision dealing in the case of APCOS, I think that's what is intended. The other point I wanted to make is CBDT should actually now be proactive to ensure that if there are pending notifications to be issued, if there are notifications that have to be issued in the future, they should be done post haste as soon as the treaty is notified or as soon as the protocol is signed. Why should there be a time lag between the signing of the protocol and the issue of notification? Mr. Pramod Kumar correctly recalled all the dates with regard to, notification of the India-France DTAA in 1994, notification of the protocol in 2000, and then the protocol was made applicable from 1/4/95 with respect to certain incomes, from 1/4/1997 with respect to certain incomes. So imagine between the signing of the protocol and the notification in 2000, which you made retrospectively applicable, there will be complete uncertainty if you have to await the issue of a notification. So the government will necessarily have to move fast in order to issue the notification as soon as the protocol is signed, in order that it can be put into motion and it can be implemented as an understanding between the two contracting nations. So I think this is important from that point of view to cut short litigation.
Just to add a small point, when you're talking about the French treaty, please also remember the French treaty had a cutoff date which was much prior to the date of treaty being entered into. As a result, some provisions of the treaty were like stillborn, completely stillborn. From the day this treaty came in force, those provisions stood amended because of the earlier treaties which were entered into.
Right.
I'm sure all the treaty negotiators were fully aware of these facts.
Right.
Interesting. One aspect that again that comes to my mind is like, okay, this is the law of the land for us because as a sovereign nation, Mr. Pramod Kumar, this question is more to you. What potential counteraction by the relevant treaty partners post this verdict? I mean, can they allege that this is a unilateral action taken by India? And what are your thoughts around that? Because we do have Indian businesses operating in those jurisdictions as well.
Frankly, so far as the retaliatory action is concerned, I don't think that's that kind of a possibility. But much more than what people do, what really matters is what people think of us. As I was saying, when we project an image of place with greatest tax uncertainty, that perception on their part does more damage than any retaliatory action that they take. Having said that, I'm sure this is, this is something which will not be taken very happily or very kindly by the treaty partners. But then in the ground, it doesn't affect much. I mean, I don't see any tangible effect of the retaliatory action. But yes, I do see damage to our cause of the nation, Bharat's cause, by creating an atmosphere in which we lose our reputation, our credibility as a place which gives certainty about how to do business, which is essential for ease of doing business, that is damaged.
So, thanks for that. And Mr. Vora, this question is now to you. Given the fact that, it is what it is today, and it is the law of the land. So today, when, companies are scheduled to file their tax returns by, it's just a few weeks from now, like November 30th. What position do people take? I mean, corporates take. Are we saying that we just cannot take the benefit of the MFN clause? I mean, I'm assuming that CBDT does not come out with any notification, or there's no guidance, or there's nothing coming in from the department at this stage, and assuming that position is status quo. God forbid that should not be the case, but assuming that, are we saying that corporates now need to take a relook at what position they're going to be adopting while filing their tax returns and filing their tax claims?
See, I would think that we need to step back for a moment to first find out where is the mismatch. There may be some MFN clauses where the notification has already been issued, right? Yeah. There may be some MFN clauses providing for a certain relief or with regard to the scope or with regard to the rate of tax. Again, if there is a variation between what is intended in the protocol and what is notified, I think it is only those kind of cases where this controversy will arise. Otherwise, if the MFN clause has been followed by a notification, then the whole issue is academic today, no?
Yeah, fair.
Yeah. But once the judgment has come, I think everybody has to reconcile to that.
Right.
I mean, we may not wish.
And the problem here would be that there are limited set of notifications that have come.
Right.
So in cases where taxpayers, considering the language as we were interpreting at that point of time, have been taking benefits under those particular clauses.
Right.
We will now need to make an assessment, because considering what has been said by the apex court now, a lot of these MFN clauses are no longer operational. So, you need to then make an assessment, taking into account where all remittances are being made, take a stock take of what sort of benefit you were seeking, whether there is a corresponding notification, as Mr. Vora pointed out, and then take a call as to what is to be done, considering the state of affairs that are there today.
See, as far as taking a position is concerned, if I was to file a return, I would take an aggressive position, because if you concede in the return, then in that situation, where is the occasion of later making a claim? If the protocol, according to you, is self-explanatory, right, and the protocol is self-operational, it is automatic. And as our view, the issue of a notification is a mere ministerial act, and if there is a delay in issue of the notification, then in the hope and anticipation that a notification will be issued tomorrow, you can take a position that in terms of the protocol, I am entitled to this relief, notwithstanding that there is no notification in place today. If the notification comes tomorrow, now it will validate your stand. If a notification does not come, you have, as Mr. Pramod Kumar said, you have a right to get to the court and say that we have signed this protocol. There is no reason why we are delaying the issue of the notification in order to effectuate the protocol. Now, those are positions that you will have to take, which will lead you to litigation. But if you take a position that the rate is higher, and in that situation you concede the stand, then I am not sure whether at a later point of time you will be able to reverse the position that you have taken while filing the return.
But at the same time, when you take such an aggressive position, you have to actually seek those remedies in the court and then take them.
Right. No, but sir, it may not come before the litigation starts.
you have to take that position, you have to seek that remedy in the court or be in a process of doing it and then take the aggressive position. You cannot take an aggressive position hoping that somebody else will take this and this is the correct interpretation.
No, but if you file the return and it gets into litigation, you will also, apart from, pursuing the appeal remedy, you will also get to court saying that a writ should be issued or notice should be issued to the government to hasten the process of issue of the notification.
Let's put it this way. My understanding is that when you are actually, seeking that remedy through the courts, you are filing a writ petition, and you take this position in the return, probably it can be justified. But if you don't take that measure and yet take the aggressive position, contemplating filing of a writ petition, that probably may not work. That's my understanding.
And, going back to, in fact, the earlier point that Mr. Vora just made, clearly, if the notification should be issued, we are talking about, yes, there are these very strict timelines right now, especially I'm looking at it from a return perspective and I'm looking at it from a year-end standpoint where, most of the overseas companies would also need to close their accounts, need to capture the tax exposure. Question is, what message are we sending, right? That's one. But the second part is in terms of the thinking behind the government for this entire issue. Why the restrictive definition? One question that comes to our mind, and that's also a question on the chat, in fact, wherein they're saying why the restrictive definition in FTS was not incorporated in India, France, DTA in subsequent notification of 2000 and 2009 in the India-France treaty.
I don't have answer to this question, but one thing I can tell you that when I wrote that ITC judgment, within I think in the subsequent year there was an article by Klaus Vogel in Bulletin of International Taxation. He used to write a column for Tax Treaty Monitor, and he expressed his curiosity. His curiosity was that if treaty negotiators knew that there is already a treaty with the US which has make available clause, and the treaty negotiator also knew that 3 months down the line, they are going to sign another treaty with UK, which has a make available clause. Why did they not as well put it in the treaty itself? So, these are the questions to which I don't have an answer. And somebody as eminent as Klaus Vogel, who has been referred to in this judgment also, he put this question in an open column published by a well-known international journal. So his curiosity apart, all I can tell you that the person who has raised this question, he's in a very elite club with Klaus Vogel.
Okay. Thanks for that. So I will, there's another question on the chat box, and I would refer this to Mr. Vora. Why Government of India speaks with multiple voices such as DGFT, Tax Authority, MFN status, etc. Our judiciary prolongs any dispute beyond, tolerable time limit. So do we want to?
I think
we should probably, I don't think this is a matter that anybody can respond. Fine, fair enough. Yeah, that's fine.
Right.
And there's one last question here which says, can taxpayer challenge the situation that when treaties signed between two countries, then is it intentional on the part of the government to not allow its treaty benefit to taxpayer by not issuing any notification? If yes, the taxpayer should be provided with due benefit. If no, then if it is just delay in issuing notification, then it's procedural and benefit should be provided to the taxpayer. I think the answer lies in the question itself here. Yeah. So with this, there are no more open questions. So I would now like to, any closing thoughts, Mr. Kumar? So I think I would like to hear you out. Any closing remarks?
I think whatever, first thing is that this decision comes to some conclusions which are quite at variance with what any student of international law, international tax laws would have learned. So the gulf between what is correct on an academic note and what is correct on a legal note has increased a little bit. So that is something which worries the businessman, in the sense the tax certainty is is a casualty in the process. That's one. Second thought which I have is that I have a feeling that this decision will be revisited. There are good reasons. And from what we hear, the way it has been projected to be constitutional issue, reference to other countries, some of these things do not really apply to the treaties under the tax laws. Because tax law treaties are quite unique in the sense that you have an enabling provision first and then comes the treaty. Unlike the normal treaties, which treaties come first and then you have enactment. And court itself has noticed this. Yet, the judicial precedents which they have referred to and relied upon are all judicial precedents in the context of the treaties which are followed by a law enabling their implementation. So I have a hope that probably it will be revisited much sooner than most of the people expect. And now that the cases which are dealing with Indo-Spanish treaty are pending, where I'm not sure as to what exactly is the issue there, this may come up.
Again, MFN, that again is the make available.
But is it on the self-operational clauses?
Yes, self-operation.
So I think this is an open issue, and of course, taxpayers will be trying for this. For the reference to the larger bench, this should come much sooner than people expect. That's my take on this.
So on that optimism, I will now direct my question. So closing remarks, Mr. Vora.
I would think that, when matters get batched in the Supreme Court, now here there are two absolutely different controversies. One is dealing with the make available clause. One was dealing with the applicability of the 5% withholding in a different setting, different context with respect to dividends, where you are seeking to take benefit of a treaty signed with a country which was not an OECD member country at the stage when the treaty was signed, but subsequently became a member of the OECD. These are two absolutely separate controversies. Now, if we were to deal with the steria case, the ramifications and the implications of holding that, the protocol must be notified, must have been seen with reference to the entire scope of Article 12 and the MFN clause. That what will be the implication if, for instance, there is a difference in the language of the protocol and the notification that has been issued. Now, all those needed to be examined. The court could have left the question of law open for adjudication in the case of steria, saying that notification had to be issued in order to give effect to the MFN clause, but the other aspects are left open to be considered subsequently. Now, here what it seems to suggest is that this issue with regard to the applicability of MFN to FTS is also answered against the assessee by setting aside the steria judgment. So there were two different matters that got batched together, two absolutely different controversies, which have got decided by a common judgment. And therefore, the implications and the ramifications coming out from this common judgment. So I think that's the danger when too many matters get batched, which have different nuances, different controversies, and which need to be then comprehensively dealt in order to give a judgment which seeks to answer the issues in both the matters, which has not happened in this case. So this is the unintended consequence so far as FTS is concerned, arising out of this judgment.
And just to take your 30 seconds more, in para 87, which is the second last paragraph of the judgment, this issue comes out more in open, where their lordships are talking about the past practice with regard to a country subsequently joining the OECD, right. And suddenly the conclusion is covering all kind of protocols.
Right.
And whatever observations which I made earlier were only on the issue of the cases other than the cases dealing with dividend, because on the dividend thing, I think by and large there's a unanimity that it was a reasonable decision. There are no questions about it.
Right.
That's the hedging I would do to my remarks.
Thank you for that. Richard, closing remarks from you.
Yeah, I think merely on account of the uncertainty it creates, particularly for the cases which are not related to the OECD member question, the question relating to things that have been done by the taxpayers for years and years altogether, which have been blessed by courts, the distinction between an automatic and non-automatic MFN. I think that is something that I really feel should be reconsidered. And if not, at least it should be made operative prospectively, because otherwise, there is so much of uncertainty today for taxpayers. What is it they're looking at? Section 154, 263, 148, 48 disallowances. So to what extent they go back, to what extent they have to bear these additional costs, to the fear of being taken as representative assessees, evaluation of all the remittances that have been made where they have kind of taken benefit of these clauses. So I think that's sort of an uncertainty, whether at this point of time the returns, if they filed it already, should they revise it? Should they, claim it should they go forward and accept it in the assessment? So all that confusion, the dilemma that is caused there, I think that is something that CBDT should address immediately. They should come up with something which, if not taking care of, the notification aspect, at least makes it prospective, so that there is closure to the past cases that is there.
Actually, if you permit, I have one
comment
to make, and I think it is directed to Mr. Pramod Kumar. Of course, he has been an author of several judgments, and now I would regard him as an international tax commentator. Sir, how do you see MLI being implemented in the absence of any notification? Can somebody take a position? You can't read MLI into the TT because there is no notification today.
Now, I'm told that they have notified the clause.
No, ratification has happened, no notification. Ratification, but there is no treaty by treaty notification.
I think your question is the answer.
Thank you. Thank you very much. It was an absolute delight and very enlightening in terms of this entire panel. Mr. Vora, Mr. Pramod Kumar, really appreciate your thoughts on this. Candid comments, candid remarks, and really quite helpful. Hopefully, fingers crossed, as a Diwali gift, I hope CBDT comes up with some clarification or notification, whatever may be, just to ensure that business can focus on business alone and not on litigation and tax matters. So on that note, thank you very much. Have a good evening. Thank you.
Thank you.